No matter how many noises are made, the law is the law. In 2 allegations, he's complaining that I misappropriated public funds to buy a ticket for my husband and my daughter to travel with me. In answer to this, I handed over my letter of appointment to prove that in my conditions of appointment as Chief Justice, Ghana graciously gave me 2 vacations in a year. The Chief Justice can never travel alone for security reasons, and the Chief Justice is always allowed to travel with a spouse or another person of their choice. Nsofori seems to be alleging that I should have traveled with my police escort alone on vacation and not a family member. And this is why he wants me removed from office.
The sadness is about the whole process. My sadness is because as far as I'm concerned, it was a very unnecessary. We have been taken through a very unnecessary situation, and which, as far as I'm concerned, and that is my honest and candid view, this has so weakened the institution of the judiciary. It's not so much the individual who occupies their position. It is the institution. That is what I'm concerned about.
I was on my common from like black media. I was Mammy Gloria Akuffo at the Simbi Ababe Tuja. I was Yara Hosem Pan, a witty mammy, some walk and witness would Pan. Mammy Gloria Akuffo, Ababe Servo, a year Ghana, or the small my Ghana, as a year Attorney General, or my Ghana, a year 2017 to a year 2021, under the government of Nado Danko Akuffo Adonebusia. Mammy, some all canon, a Yara Hosem Tress, was say. Who is a president of Really in Mahama say pan or be Ebu man will pan dia and your bay say a quanya wafaso at their pamo a Chief Justice get to Tukuno or General one net or channel addition on Tiasi. No, dear, no Mississippi or small man say a year Ghana near what me about modern pass or main a bit me fun into my pa a flare back a mum kept your memo. And so President of Really Mahama, dear no year and for so bakusi crampo in Isua. With him, my minister, my walk crampo as Wunya and Cobebo modern so beside at Yasemi, I call appeal course. So Ebusia, Mammy Gloria Akuffo, Kasa, the Yawpan, a Rewoni Sum, and a Kasa Ghana force, a Beya Ghana for sorry. Now, Omuntimi and pleaded on the behalf of a year Chief Justice Getru Saki Tokunu, Ayapamono, Ebusia, and some of my Kayano, and some Ketua, and Peso coming Quadin Chimunia for Froka, Bessie. I was a baby, I will show me be our how near Mania, but then the beer that was Subiano. But what they say, when we be doing Como, yet the Samana was to be Abba, a friend say, a Yesika Coco, and now go the Samana. But how beer that was to be a we have Samana we say be. I think we are Bema or Shano, Bema, some more from Obama, a Ketua, Rabeji Bula Matali, a Druby, now Bema, and Yakasi, waiting up boy, Jumanso Ache, our MP. Yet they are Quanchirebi Abba, a Buziania show Shibrim. I friend the same for country and I say we to my friend back to sender. We need to be how we need to be tata. What to bet our hosa was sanity will be cool. But what days of the fan numbers in the screen I say now only me a casa me show Shebremuja. Never more days a match near Obey.
Very sad about it. It has really saddened me. And maybe in a way I feel very distressed by it. Yes.
In terms of the conclusion that was reached, where the matter has journeyed from, is the sadness as a result of the conclusion, or you have questions about the procedure that took place before that?
The sadness is about the whole process. My sadness is because as far as I'm concerned, it was a very unnecessary. We have been taken through a very unnecessary situation, and which, as far as I'm concerned, and that is my honest and candid view, this has so weakened the institution of the judiciary. It's not so much the individual who occupies their position. It is the institution. That is what I'm concerned about.
I mean, what informs the conclusion that it's an unnecessary process? I mean, we have heard even government spokesperson make the point that a petition was sent, a committee in line with the constitution was set up, they've looked into the matter and they've come to a conclusion. Which aspect of it, what specifically makes it unnecessary?
I think that, you see, there has always been something wrong with Article 146, and particularly with the procedure that it sets out, and especially as it regards the position of the Chief Justice. In the Ajay case, I took the opportunity to reflect on that weakness that I noticed, and unfortunately, what one saw wrong with that procedure as set out is what has come to pass. Because one, it's a provision that sets very vague criteria for or very vague grounds. Misconduct. Misconduct. I hear you're a lawyer. Misconduct ranges. There's no particular description of misconduct. Your child can misconduct themselves in school by chewing gum. That's misconduct. Chewing gum in court could be labeled as misconduct. Misconduct simply means that somebody, in somebody's view, you have misconducted yourself. There has not been, it's one of those standards, if one could call it that, which is incapable of any definition, and to a very large extent it is personal, it is circumstantial, it is dictated by so many things, and one needs to be extremely careful. But that aside, well, and then incompetence is also another vagueness, because incompetence, it could be you didn't know what you were doing, but one should go beyond you didn't know what you were doing and go to consequences of it, etc., etc. And then of course there's the third one is infirmity, which I could be, one may say, the only possibly objective ground in that provision. And one had always, certainly when I was Chief Justice, I was walking on tiptoes. When am I going to be accused of misconduct? When am I going to be accused of incompetence? And are these and these are not so, to me, they lack the gravity. They lack the gravity that would lead to a grave outcome, such as the removal of the head of an institution of justice. I've deliberately phrased myself that way. It trivializes the position, and I wonder what this is going to lead to further on along the line, because every judge is fair game and every Chief Justice is also fair game.
I mean, is that to suggest that you suspect there could be a ripple effect in that?
Oh, definitely. It's not suspect. I foresee, not tomorrow, maybe not next year, maybe not in 5 years' time, but along the line, yes, unless those provisions are dealt with effectively in a revised constitution.
Maybe a more direct question. I have seen the letter that was written by the secretary to the president to the former Chief Justice.
And that's the other thing. A warrant, a person holding a presidential warrant. That's what the position is. You become Chief Justice because you have received a presidential warrant. You can receive all kinds of letters that you are hereby appointed, but if you don't have that warrant, does that make you Chief Justice? Yeah, okay. So if you're removing the person from the position, is it a subordinate who signs the letter? Is that the way it's supposed to be done? That's just by the way. Food for thought.
Yeah, but I've seen a warrant as well signed by His Excellency the President.
So why are they showing us that one? I've been receiving all kinds of messages, and every one of them is only bringing out that letter. And in any case, is it polite? Is it proper that it should be a subordinate who writes a letter of removal to a Chief Justice? Really? Really?
I was making reference to the letter because it quotes portions of the committee's reports and the recommendations, and they make reference to the travel expenses. One, they also make reference to the transfer of one Mr. Baden, and thirdly, the suggestion that she made to the president by way of names to be appointed to the Supreme Court. Do you think that because of the concerns you've raised about misbehavior and incompetence, do you think these three matters, if they've been proved as the committee has established, constitute misbehavior and misconduct as envisaged under 146?
These are, okay, let's take them one by one.
Yeah.
There's the matter of transfer of staff. Transfer of staff is, well, I am not going to go into the details and all that, but transfer of staff, one, it is not just at the whim of the head of an institution. Normally, transfer of staff is something that will come before the council, the Judicial Council. But transfer of staff is a normal and common and ordinary part of running an administration. When I became Chief Justice, I transferred a whole lot of staff, including even judicial officers, for various reasons. Not for punishment. No, to me, transfer is not a punishment. Sometimes transfer is even a career development move. But it is also a neat way of running an institution. You don't stay in one place forever, because the longer you stay in one place, the more harmful you might become in that position. You need to be tested in other places and in other positions.
The concern that was raised was that the clear terms of the travel policy in terms of what it provides for and the trip she embarked on was not consistent with that particular provision, for which reason the committee said that, in fact, they said she had burdened the funds available to the judicial service, and that they believe amounted to stated misbehavior and misconduct. And
was her attention drawn to it because that's why you have auditors. That's why you have people who go, because if my memory serves me well, throughout the time I worked in the judicial service, including when I was an ordinary judge and when I became Chief Justice. When you're traveling, certainly you're not the one who even dictates how much should be given to you. You are given an amount of money. If it is supposed to be accountable, you are informed that it's accountable. If it isn't, you are told. I always ask, is it all mine? And if that is it, then that is it. So whether it was an overpayment, whatever it was, because when somebody is traveling, even the administration of that travel has to be something which those who are drawing up the documentation for the withdrawal of the money and all that, they are supposed to do it with reference to policy, is it not? I think that is how it is in every organization. So, and sometimes there could be overpayment, and then you're notified that and sometimes it's months thereafter, and then you were overpaid because maybe the trip was shorter for one reason or the other, or the rate was different, and so on and so forth. And then you're requested to refund, isn't that it? Yes. So this, if at best, because I don't really have the details of the proven facts. Yes, I have some idea of the allegations, but of the proven facts, those I don't have. And so all I can say is that, yeah, I don't think that is sufficient.
I mean, another issue had to do with the recommendation that was sent to the presidency. I mean, there have been a number of Supreme Court decisions that have commented on the appointment of superior justices, the process that takes place. But those who raise the issue...
There have been a number of
Supreme Court decisions
as to the procedure.
I remember
really, such as
the Ghana Bar Association versus Attorney General.
Which of them?
The one that had to do with the appointment of Justice Kwamine and Justice Yawapel. There was a recommendation from the Judicial Council, a number of names, and the point was that it was in a certain order, and the president had gone below, so the GBA sued. And the concurring opinion from Justice Jones Doche, he discusses that the procedure is such that the various arms have to play various roles in terms of making the nominations. There are those who say that the Judicial Council plays a role, but the letter that she wrote to the president, that letter was specifically signed on her behalf. She signed it as the Chief Justice, writing directly to the president who heads the executive, mentioning specific names of individuals who she believes should be appointed because of the shortfall that she was raising concerns over. They say that that is unconstitutional. That's the conclusion of the committee.
That at best, that's mismanagement or a management mistake. Is that so? What did it result in? What did it result in? I'm asking.
I mean, but my lady, respectfully, the courts have said that an unconstitutionality is a matter that cannot be remedied, and so the very existence of the breach itself is a problem.
But for example, let's say that a decision is made, a judicial determination is made by a high court judge, who by the constitution does not have that jurisdiction, but they went ahead and made that judgment. Is that sufficient to get rid of the judge? Is it? I don't think so. Because at the end of the day, that decision is appealable, right? And would be appealed against, and ought to be appealed against. And in any case, if it's unconstitutional, it is without effect. It is null and void. Right. To me, if you make a recommendation which is not the recommendation that ought to be made, or the method, the mode by which you make the recommendation is not in accordance with the process. And I need to point out that it's one of the unfortunate things, that I noticed when I was Chief Justice, that the process for selecting and then for recommending people for appointment had a way of changing from time to time, which I found rather unsatisfactory, because at the very least what one would need is to have a properly stated procedure for it. Because even how you first initiate who is going to go into consideration, there have been so many different ways of doing it. For example, nominations to the Court of Appeals. I've known situations where somebody applies, where it's by application, and then you even sit exams, and then you're shortlisted, and then you're interviewed, and then the outcome is one way or the other. That was for a while, and then it was decided that at that level it was not palatable that they should sit exams. Elevation to the High Court, they've been taking exams. You take exams, you are interviewed and everything. At least that's as I knew it. I don't know about now. And to the Supreme Court, it is in terms of how you arrive at the names of the people to be recommended by the Judicial Council and recommended to the President. That too has varied in one way or the other. Some of us always felt that let's state a policy and stick by it. Other times it would be names coming from left, right, and center, and it's all a big mess. So when you say that, and all these are procedural rather than the Constitution says that it goes to the maybe what it starts with an application, or it starts with headhunting, or it starts with picking a name out of a hat. There are so many vague areas when it comes to appointment of judicial officers, and it's been one of my personal big concerns, and that's another thing which I hope the amended or the revised Constitution is going to deal with. One, how are they even seen first? And then what is the process by which you make your selection? And what is the sifting procedure? All that. If you go looking for any document that's going to give you step by step what's supposed to happen, like if you go to, let's say, any of our banks and you want to know the procedure by which somebody becomes is employed as a director, you will see where it is, how it is initiated, where it starts from, and so on and so forth, and all that and all that. As far as I'm aware, it's not like that even in a greater part of the public sector. And it's an it's a weakness and it's an omission that needs to be seen to. But with regard to the Chief Justice, okay, so she sent a list of names to the president. That's what she's supposed to have done, right? And then what happened? I
mean, the appointment was not done, but the committee takes the view that that was in breach of the constitution.
That's petty.
That amounts to a breach of the state misbehavior, amounts to state misbehavior as well.
I beg to disagree.
I mean, and you say that is petty. Why that conclusion?
Because even in major cases, you're a lawyer, right? Not a law student, you're a lawyer.
To be called to the bar in October.
Oh, well, then you're practically a lawyer. But I think one of the biggest, first things you learned was that you can get it right and you can get it wrong. The question is whether it is correctable. Is it not? In major cases, in capital offense cases, the trial judge can get it wrong, right? And that involves somebody's life, whether they're going to be found condemned to death, or they're going to be put into prison for life. Even that is not so gross as to lead to the judge, he got it wrong. Yeah, I got it wrong. You can get it wrong, you can get it right. So that is why I keep asking, and then what happened? Because in the end, you look at the gravity of the harm that was done, if any. If any. That's all I've got to say on that.
So as far as you are concerned, that also does not meet the threshold in your definition?
No, doesn't.
Do you think, and this is a general question, do you think from what you've heard about the allegations, it should have crossed the threshold? I mean, I've seen suggestions that you abstained from the vote at the Council of State level. I
cannot reveal what happened at the Council of State
but then
level.
The question is, do you think it crosses the threshold of a prima facie determination?
You think you can get me to?
No, my lady, it's a separate question.
You think you're separating it.
You have expressed an opinion on the three allegations that we discussed.
Yes, and so deduce. Deduce from what I've said. Yes.
Is it a fair deduction to say that your opinion is that it does not cross the threshold?
It does not cross the threshold. You know, you've already done your criminal procedure, because once you're bringing in a prima facie finding, you're sort of skirting the lines of criminal procedure more than you will be skirting the lines of civil procedure, right? Okay. And I do not think that if these were criminal allegations, any of them would cross that line whereby the case has been made out, because the part I played in this matter was only in terms of prima facie, and prima facie only has to do with the facts as they are before you, or the allegations and any supporting fact, any supporting material as has been presented to you. Isn't that it? Mm-hmm. So, like I said, I didn't see what is in what came before them beyond what I had earlier on seen. And what I had earlier on seen was insufficient. Yes. It didn't even cross into the inquiry stage.
So a committee, in your opinion, should not have been set up to inquire into it?
I think it follows, doesn't it? It follows.
I mean, a number of your concerns rest on a lack of clear laws in place and everything. To the extent that the committee was exercising discretion and their own understanding of some of these laws and applied it, would you disagree or agree with those who say that no clear-cut provision has been breached in terms of from the start of the procedure for the removal to their conclusion?
Well, what procedure? That skeletal framework that's in the Constitution? See, that's a very. I want to take you back to the Ajay case. See, in the Ajay case, the court, the matters had only just begun. The process had only just begun. So we couldn't really go deeply into other aspects that could have come up. But the court perceived, rightly so, that the procedure that has been set out for the removal of the Chief Justice fell so far from normal standard of justice that we had to read a procedure into it. For the simple reason that for the removal of a normal Superior Court judge, there's a stipulated need for a prima facie determination. And then for the removal of the Chief Justice, there was no such thing. Yes. And so we read the need for, because otherwise, why should it even go to the Council of State? If it goes in and it comes out, what would have happened to it? It goes for them to look at it. So we decided that there too, there has to be prima facie. Because when you're dealing with constitutional processes of this sort, there are all kinds, it's nuanced. And you need to, as much as possible, shore up the provisions to reduce the room for play of nuances. You need, so as to create more certainty. I think that's the best way I can put it. We didn't get to the stage where we were to determine, okay, I am the one who speculated. It was Obita. Yeah. But the court itself did not go into are the grounds sufficiently clear. We didn't go into that. But this was an opportunity for that to be also done. Yeah. I've done in connection with the article, I had to do a prima facie finding once, and I certainly decided to go. I treated it like I'm a High Court judge who's making a prima facie finding in a criminal case. And the standard had to be really very high. And at the same time, one also had to take into account the circumstances. See, because stated misbehavior simply means you're supposed to have misbehaved in this regard. But as to whether it has the weight to amount to misbehavior that should have certain consequences. That is an evaluation. That is also nuanced. Yes. And in my opinion, most of the things that had been brought against the respondent, I threw them out because de minimis non curat lex. What does that mean?
The law does not concern itself with things of trifle, not substantive matters, not little things. Yeah, but if I'm to ask directly, would you say that the former Chief Justice got a fair trial, if I'm to put it in that manner?
In my, you want my opinion, you want my legal opinion, you want an opinion from the heart and the mind and the soul and the spirit? No, she didn't. She didn't. And there were also other things which in the latter part of the proceedings also happened, which I don't even know how to put it, but they were very unbecoming. One, a process that is supposed to be purely in camera, and that expression in camera has been defined by the Supreme Court, and that definition still remains, right? That from the complaint all the way till the president speaks at the end of the matter, it's all what? It's all to be treated as part of the same thing. It comes under the same cover of in camera, and therefore is supposed to be confidential. So you can imagine the umbrage that I felt to receive on social media some social media thing somebody had sent to me, where the fact of which I am not in the least bit ashamed, and if I had to do the same again, I will. The fact that I had gone to give evidence before the committee was on social media. How did that get there? And it was not only myself. So and 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 so. I'm not going to repeat that. I won't use the word that came on my lips. I'm not going to repeat that unbecomingness by even mentioning the names that were mentioned. Isn't somebody entitled to have witnesses on their behalf? And then to come to think of it, then I thought, yeah, but we don't even know who gave evidence on behalf of the petitioner. So why is it that those who gave evidence for on behalf of the respondent, why should we be thrown to the rabid dogs? Because there has to be some not very noble motivation for that. And when it says that they from quote and unquote sources close to the committee, oh really, that is so sad and it's so pathetic. And then on Sunday, somebody sends me another thing where somebody's going on and on and on and on and going on about the legal submissions that had been filed on behalf of the petitioner. Really? Why? Why? What's the game? What's going on? I felt sad, and even that in itself made me sad. Have we come to this in this country where a process, The most important thing in every process, whether it is a formal judicial process or it is the most informal process, such as, let's say, ADR discussions and all that, where something is supposed to be confidential, it has to be kept.
But to the extent that the Supreme Court has determined that if there is a breach of the in-camera rule, it does not invalidate the process, should that still be of concern?
That does not matter. I'm still talking about it. Just because it doesn't breach it, it breaches the letter. It breaches the letter of the Constitution, does it not? That it should be confidential. I'm not saying it therefore means anything, but all I'm saying is that for me, it puts an unpleasant aroma onto the procedure, because process integrity is exactly that which is demanded of the most humdrum, the most mundane inquiry, let alone an inquiry into whether or not a Chief Justice should be removed or not.
Outside of that concern, what other matters constitutes the basis for your conclusion that you don't believe she got a fair trial?
Oh, I didn't say she got, maybe what I meant is she got, after all, it wasn't a trial, even though it was handled as though it was a treason trial.
Why do you say so?
Because that's how I feel. Because that is how I feel. Am I entitled to feel? Am I?
Yes, but to the extent that the petition was sent, a committee...
Listen, a petition was sent, it went to the Council of State, it came back, a committee was set up. Yes. Then you get into the qualitative aspect of things. And you see, my upset and I won't use the word anger, because I don't waste my anger on certain things. But my discomfiture also arose from the fact that when the Chief Justice, and that one is a matter of public knowledge, right? When she applied that, okay, since the pleadings are all now out there in the public domain, why can't we simply have a public hearing? She was told what? No, it's supposed to be in camera. It's supposed to be in camera. Everything is confidential. So I go to an in-camera process to give evidence, and then it's out there in the public domain. Approbation and reprobation, that's the way I see it. The committee, either it was not protecting itself properly, because really, who came? Because as I was walking into that building, I didn't see any paparazzi within sight. Okay? Nor did I see any person surreptitiously maybe taking pictures or anything like that. So, how it got to the press that so and so plus me, we had given evidence, I think that is wrong, and it was in bad faith, and it was in bad form, and it was not in consonance with the due process, the due regard that is dictated by an in-camera process.
In the course of the hearings, there were a number of court decisions.
I didn't follow any of them.
I mean, the multiple attempts, and I'm asking this because some of the concerns that you've raised were all matters that were put before the courts in one form.
I did not
or the other.
follow any of them. The few that I didn't really follow the details of them. Some of the outcomes were a little too predictable. I didn't follow because as far as I was concerned, the whole thing shouldn't have been happening in the first place. So I had shut my mind to the whole process. After all, I'm no longer a Chief Justice. My sole role in the whole matter was whatever came before the Council of State. That was passed. How I felt about it, how I didn't feel about it, was neither here nor there. So why should I follow it? And at this point in time, I'm not even going to say the Supreme Court was right or was wrong, or this court was right or was wrong. That's all neither here nor there. It has happened. And all I can say is that I just pray to the Lord that no judge and no Chief Justice henceforth ever has to go through this rigmarole again. That's all I've got to say.
In commenting on the decisions, you used the word predictable. If you could explain, is that to say that predictable in the sense that it was the conclusions that the court ought to have reached, or you mean predictable in a different sense?
It was predictable in the sense that, well, not all of them, but some of them were predictable because one knew what to expect. Not because the law said so, but the law was, there was room for discretion, and it didn't happen. But then you cannot fault somebody for not exercising a discretion. That's not a big deal.
Do you think the entire removal process was politically motivated?
I refuse to answer that question on the grounds that it might incriminate me, quote and unquote.
Incriminate in what sense?
I said quote and unquote. I'm not going to answer that. I mean, observe, and everybody can make their own conclusions. That's all I can say. Whether it was, whether it wasn't, it has happened. So I'm not even going to comment on that.
When the committee submitted their reports to the president, they did indicate that they had concluded work on just one and they had adjourned on the others. There are those who have taken the view that the committee perhaps should have waited and finished with everything before submitting the reports. Where do you stand on that?
Well, all I can say is that I found it a very peculiar I found it peculiar because having brought in the first report, it has been acted on and the matter is now moot. The rest of the complaints are moot now, aren't they? Under what circumstances and for what reason and with what justification is Justice Tokonu going to be dragged before any committee to answer to the remaining petitions?
What do you think would have been appropriate for the committee to perhaps finish the complete work before submitting the reports?
You know very well that when somebody has done their, in a situation where there are no hard and fast rules, and a body has decided to proceed in a particular manner, it becomes difficult to say that. The most you can say is that if I was in charge, I wouldn't have done it that way. Yeah, because that's why cases are consolidated, and or you hold on, and then you come up with your conclusions when you have concluded the process. So is the process complete or is it not complete? That's the question. But I think it is complete. Is it not? Yeah, it has a terminal outcome. It has created it has had a terminal outcome. There's nothing left. So I'm even surprised mention was made of those other petitions.
If there's one lesson you think should be picked from all what has gone on in the last couple of months, what would that lesson be for you?
That constitutional provisions that purport to deal with the removal of persons from their positions, however high, however low, ought to be crafted with more precision and have greater detail. Because if in your constitution you're going to go to the extent of setting out grounds, setting out procedure, and saying that this is the only procedure that is to be used, then it needs to be more solidly grounded. It needs to say more. Because what the Constitution could have said, actually, would have been that etc., may be removed in accordance with a law to be made by Parliament. Because just like there are other provisions of that nature, that could have been done. But once you stipulate that this is it, then there should have been more substance to it than as it is in the present Constitution. So any takeaway, any lesson, not for me. I'm over 70. I'm in the departure lounge. But it's that when it comes to constitutions, what is inside it, how it is phrased, the specificity with which it ought to be phrased should all be carefully looked at. Because every constitutional outcome is not towards an individual. It is towards the nation and its future.
Okay. There's been a bit of legal debate. Just final two questions. There's been a bit of legal debate on the effects of the removal, whether it affects her role as a Supreme Court judge as well. The warrant that I have seen removes her from office as Chief Justice and Justice of the Supreme Court. Is that the understanding of what the 146 procedure should lead to in respect of the Chief Justice?
See, that's also another gap. That's what I'm going to say. That's also another gap, because it has to be dealt with. And because just yesterday, except I wasn't really paying much attention, but somebody drew my attention to something in some decades past where somebody was removed as Chief Justice but went back to serve on the bench because of the terms in which the removal was couched. I think it was by way of an enactment. I can ask the person to give me more details just for edification, but you know, I don't want to go into academic debates, and I will rather, this is as far as I will go with answering the question you have asked, because for all you know, in this litigious country, somebody may bring the matter before the Supreme Court just for the heck of it, and I don't want to put my mouth in there.
And finally, I mean, if you were to say something to the former Chief Justice, what would you say to her? I mean, and secondly, do you think that we need serious, clear-cut reforms to guide this entire process?
I think I've made it quite clear. I'm answering the latter part of your question. Yes, clearly. Not only whatever will be in the Constitution, but even in terms of the procedure before the committee. There has to be something there. Yes, under the general law, every committee sets its own procedure, so long as they do not breach the rules of natural justice. They are legitimate, but there are all kinds of nitty-gritty matters that it would serve the nation better if it is all there in the law or in the Constitution, and it is there for everybody to see and for everybody to know, because that is why criminal procedure is more of a technical part of the legal instruments than civil procedure. Civil procedure has a lot of discretion, but because of the nature of the possible outcomes of any criminal process, criminal procedure has a lot of imperatives, and that is what is needed for this kind of activity. Because you know, it's not only judges who can come under the Article 146. All the constitutional bodies, the heads, yeah, and even that, I have serious problems with that. I mean, can you imagine? God forbid, but proceedings are being brought against the Auditor General or the Accountant General, and that process, because these are all classified as of the rank of Court of Appeals judges, so this becomes the headache of the Chief Justice. And what does the Chief Justice know really about the work of the Accountant General that will enable you make prima facie findings if there's all kinds of technical things he's supposed to have done and not done, and so on and so forth? Yeah, judges, we make decisions about all kinds of things, but we don't know everything. And when it comes to the arcane areas about the workings of accounting and audit and so on and so forth, there's a limitation on that. So those provisions, they need a real serious so that the removal of some of these positions would be done by specialized bodies. It's only fair, right?
And the other part of the question?
The other part of the question, which is what? I've conveniently forgotten. Yes.
And if you had the opportunity to speak to the former Chief Justice, I mean, she publicly expressed serious concerns about the process that she was going through, that she felt it was unfair. It's come to an end. They've removed her. If you had the opportunity, what would be that one message to her?
That she should take heart, that God sees. And sometimes when you go through certain things which you think have brought you to the end or to your knees or something like that, that could be far from the truth. There could be bigger, better, and greater things that the Lord has in store for her. That is what I will tell her, and that is what I'm going to send to her as a text message. Because when you're a believer, things happening today, yeah.